So the first one is that I've used my trademark for years. Why should I register my trademark? Don't tell me I don't have any rights. Well, you do have rights. And in Malaysia, you have better rights than some countries, because in Malaysia, we have the rule that first to use have more rights than first to file. So the person that first uses the trademark in that specific country has better rights than the person that rushes to the IP office and files the trademark application. Some countries do not even have the first to use right, and they have first to file. Examples of first to file countries are the US and China. So thankfully in Malaysia, parties that first uses the mark in Malaysia has better rights than the person that is first to file. So even though you've used your trademark for years and you do have first to use rights, you should still register the trademark application and have a registered trademark for this specific reason. When you have that certificate of registration, that's clear evidence that that is your trademark for that specific service and for that specific product. So if anyone trespasses that rights, it's very easy to take an action against them in court. Otherwise, even though you have first to use rights and you have rights, unregistered rights, because of many years of use in Malaysia, what will then be your cause of action in court would be an act of passing off. So it's a lot more difficult to take an action in court for passing off. The reason is that you have to prove three things in court. Okay, the first one is that you have to prove that you have goodwill and reputation. Second one is that the other party has misrepresented their business as if it's your business. Third one is that you have suffered damages. And to prove that you either have lost sales, lost profit, or that the other parties gained profit from that misrepresentation. All of these three is difficult to prove in court, and that's why having a certificate of registration and immediately saying that I have rights, he had no rights to enter this market, that's a lot easier. So remember that there is a misconception that you've used it for many years, so why bother registering it? There are a lot of benefits of registering it, and that is the main one, that it's easier to take an action against a competitor in court. Right, the second misconception. Second misconception is that I have registered my trademark, so it covers everything. It covers everything it covers every product under the sun, or every service under the sun. No, that's not true. That's incorrect, because in trademark law, not just in Malaysia, but in other countries as well, the classification of trademark is broken down into specific classes. Some countries, in fact most countries, follow the NIS classification system. The NIS classification system has 45 classes of goods, 34 for goods and 11 for services. So depending on what area of industry you're in, what products you're actually selling, what services you're selling, you might actually have only one class that is relevant to your business, or more than one class that is relevant to your business. So when you have a trademark register, it's very important to, number one, make sure that you're protecting it under the correct class. Having it registered under the wrong class, it's the same as not having it registered at all. Second thing is that make sure when you have a trademark registration, apart from knowing that you've registered it under the correct class, it's to make sure that as the business grows and expands, the other classes that are relevant to your business are also protected. And examples, we even give you an idea of what I mean, because I'm talking about classes and it sounds extremely theoretical. Let's say you're in the fashion industry, and everyone in the fashion industry normally starts out with apparels, they start out with clothing. And class 25 in the trademark NIS classification system has clothing, headwear and footwear under that specific class. So in a few years you decide that you want to sell jewelry or belts or bags, for instance. All of those, jewelry and bags and belts, fall under a different class, class 14 for jewelry, for instance. So as you expand and you get into different product lines, there might be other classes that are relevant to your business. So there is no such thing as my trademark covers all. It is a specific class, and as time goes on, you might even have more classes. And having it registered in those classes are important, all because if someone infringes your rights, it's easier to take an action, especially if you have it registered under the right class. Right, the third misconception is that I have registered my trademark. So what's the big deal if I start selling my products or start venturing my services into another country? It's registered, right? So I have rights. So that's a misconception, that a trademark registration in a specific country gives you universal trademark rights, worldwide rights. Trademark rights are territorial in nature. The rights that are given to you, that monopoly for many years, because trademarks are renewed every 10 years, so that monopoly that's given to you is given by a government in a specific country. And that's why you lodge it at the IP office, which is a government body. The government gives you that monopoly, and because of that, that right is territorial in nature. That's for that specific jurisdiction. They'll do a search, and if that trademark's available in that country, they allow you to register it. So to say that you have a trademark in Malaysia does not mean that you have rights in Indonesia, in Singapore, in Thailand, or in other countries. So you have to always take a step back and observe where your market is. Have you registered it in all the countries? Yes, it might be a costly procedure, and trademark registration is country by country, as I said, but in some regions you can do a regional application. Take for instance in Europe, we call it the community trademark. One trademark covers all the countries in the European Union, and there are some regions in Africa as well where one registration covers some African countries. So that could be a cost-effective manner. Unfortunately, in ASEAN, we don't have one trademark to cover all the ASEAN countries. There is, however, an effective foreign filing system. That's called the Madrid Protocol system. There are some countries that have signed a Madrid Protocol treaty, and the countries that are members of the treaty can allow applicants to use the system to make it effective to file in other countries. So it's not as if you file a Madrid Protocol application and you get protection worldwide. No, what it is, it's an easy way to lodge a document, and this document is actually lodged in the World IP organization based in Geneva. You lodge the documents with WIPO, and they will disseminate the documents to whichever country that you're interested in protecting your rights at a later stage. So the difference is that your application goes to Geneva, and then they disseminate to the other IP offices. Whereas if we didn't have that Madrid Protocol system, you would have to go directly to each country. So let's say you have 5 countries, you go directly to 5 countries, and not directly to the IP offices of the 5 countries. You will file it to the lawyer or the trademark agent in those countries, and they will lodge it at the IP office. So there is a lot of cost saving in this Madrid Protocol filing system. But now, I'm going too much into the whole process of Madrid Protocols filing, and I could spend a whole day on that. What I'm trying to say is that there is a misconception that if I file in one country, it covers all countries. So no, it's not. It's jurisdictional, and you have to take a rain check on where you have registered your trademark, where your business is.